I'm Paul Brownstein, attorney here in Bucks County, Pennsylvania. And today I'm going to talk about things that I do, but not as much as some other things that I more often do, like family law, domestic relations, and real estate. I tend to sometimes get hired, often by clients I already have, for things like drunk driving charges, which is a very, very common thing that average people have who aren't bad people. Because you don't have to be a bad person. You don't have to be a criminal to have had a drink, to celebrate, to have a party, to be at the bar with your friends, and pull out on the road just in time for you to be noticed. The first thing you have to understand in drunk driving charges, you cannot be stopped at all, unless it's a routine traffic stop, unless there's been something that's happened called probable cause. Probable cause, what it sounds like. The officer has to have some reasonable basis to believe you've done something wrong to stop you at all. If they can't produce something that made them think you broke the law somehow, then anything they may have discovered as a consequence of stopping you cannot be used. In law school, we learned to call that you can't use the poison fruit that comes from the poison tree. And once in a while that's true, but pretty much, if you've been stopped, you've done something to catch attention of the officer. A bad taillight break, maybe. Weaving on the wrong side of the road. You're drunk. You were going too slow because you're being careful and noticed for that reason. Driving in a neighborhood where you're not known by anybody, acting suspiciously, driving too fast, etc. I think you understand. I'm sorry to say, often there will be probable cause. When the officer stops you, the first thing they're going to do is a field sobriety test. Besides asking who you are, where have you been drinking? And people always say, oh, you only had a couple. Not a good idea. They remember that, they write it down. But anyway, you get stopped, and they do this field sobriety. Walk the lines, see if you're straight, can you keep your balance, those kinds of things. And then they take you to the hospital, not because you're ill, usually, but because they're going to take blood. You can't refuse. There are reasons why taking the blood might not work, or why refusing it might not work, but it's a general matter for our discussion here today. If you are asked to take a blood test, and you refuse, anything but an immediate and routine yes to all of it is considered generally to be a no. If you do not take the blood test, even if later you can show you weren't drunk, you'll still be suspended for up to a year by PennDOT because refusing is regarded to be a violation of your rights to drive, because driving in Pennsylvania is a privilege, not a right. And the privilege means you must honor the things that give you that privilege, like obeying all rules of the road and things like, cooperating if they were going to take blood. So don't fail to do that, because the only reason I can ever think of why you would want to refuse the blood is because maybe something worse is going on, like serious drugs, and you don't want to find that out in your bloodstream. That can happen, I suppose. All right, so you've been charged, you'll get the notice of it, and then the question is going to be, what will happen to you if this matter has to be handled? Generally speaking, if it's not the first time you stop for drunk driving, then most likely, because you have prior offenses, you're going to have to pay fines, and there may be some jail time. Minimum 48 to 72 hours, maybe more based on how long it is. And under Pennsylvania law that just recently changed, a third time DUI offense, regardless of the amount of alcohol may be, third offense is now a felony in Pennsylvania. Very serious matter. Lots of jail, plenty of fines. Let's assume that it's your first time offense, as is often the case. If you are a first time offender, that's the cop word, the court word, for people that have done bad things with the law. You're an offender. You're the perp. But let's say that you're the offender, and it's the first time you've gotten involved in criminal misconduct. You haven't been arrested and charged and found guilty of shoplifting, of being involved in a bar brawl somewhere and going to jail because you beat somebody up when you shouldn't have. That you haven't robbed somebody. You haven't got prior DUIs. What you've got is a first time offense. And this offense, this time, you're not guilty of any violence. If you haven't gotten involved in a fight, you didn't wreck your car against somebody's house, which is regarded as violence, you're a first-time nonviolent offender. Then you are qualified, almost always, for what's called ARD. ARD are letters for Accelerated Rehabilitation Disposition. Fancy way of saying a special kind of probation available to first-time offenders. The probation will require that you pay the fine and that you go to driving school, assuming it's drunk driving, and that you also do community service of some kind. If you do all of that, you can qualify for the ARD program, and the ARD will be based upon what's the actual qualifications, which are more technical than worth discussing here. You've done what you have to do, and you're in the program. You'll finish serving the probationary period, during which you'll be suspended. A month to 3 months usually. Probation 6 months to a year commonly. At the end of the probationary period, the record will be automatically expunged like it never happened. A great deal for people that are not bad actors and had a one-time bad mistake. And you can then always say you've never been convicted of any crime and you're a good person, and that's great for your record if someday you're going to become a pillar of the community. And you would not like it known that once upon a time, like certain politicians in Virginia right now, did bad stuff when you were young people, that now are not anymore as well blinked at as maybe once upon a time they would have been. Not saying what they did was right, but you wouldn't want something from the past come back to haunt you when you could put it to rest if you could. So you'll do that. Couple of things to keep in mind when you're on ARD and you're suspended. If you breach the ARD, it'll be revoked. If it's a second DUI, you'll be back in court. The ARD is gone. That's your first offense. Now it's a second offense. You'll be spending time in jail, and more than the first offense and bigger fines. So you don't want to do another drunk driving. Also, you don't want to be driving, period, while you're on ARD. Under the law of Pennsylvania, if you're driving while suspended, if the suspension is because of DUI, you will do time in jail and you will find your ARD revoked. PennDOT is not forgiving in this department. You'll spend time. Like I said, in the third offense DUI, and you're on ARD somehow, you'll spend 6 months in jail. You can spend time in jail anyway. You don't want to drive and lose your ARD. This is difficult when in a suburban environment. I'm here in Bucks County. I do Montgomery County. Maybe Philadelphia's not quite as bad. It's kind of hard to get around without driving. It's even harder to get around if you wind up in the clink. Or if you haven't got a driver's license now for another 3 to 6 months or more. I've had cases where there were multiple suspensions. And I remember one recently, they were suspended out to the year 2032. You might as well never drive again. You learn to find out what Uber's all about. Do not do this. As I said earlier, you don't want to do these things yourself. You don't know what you're doing. If you read up on it, you'll get an idea, but that won't help you if you have to do it. For that reason, get experienced help. After all, when it comes time to legal matters, it's your life. It's your property. It's your freedom. When it really matters, the choice is simple. When it really matters, the choice is simple.